Hi, I'm Katie James. I'm the Chief of the Office of Victim and Survivor Rights and Services, and that's under the Department of Corrections and Rehabilitation. Our office was established in 1988 under then Governor Wilson. We can assist victims post-conviction when the offender has been sentenced to state prison and has been convicted through the courts. We assist them by explaining the process of transfer from county jail to our institutions and assist them with understanding what their rights are as a victim while the offender is under our custody. Once post-judgment, post-conviction, and CDCR has jurisdiction on that offender, we will be able to help the victims through the post-criminal justice process. We assist them with notifications of release, notifications of discharge. We do notification of transfer. We also do notifications of parole board hearings. Our office assists on restitution collections, and our office also does notification of governor decisions that the governor might make on a case. And we have a large component of our office that's restorative justice, which offers services for victims to heal, maybe meet with their offender, possibly participate in an apology letter writing process. So we use what's called a Request for Victim Services form. It's called a 1707 form by the department. It's a form that you can access on our website electronically. We also have an electronic submission you can do on a portal on our website. Also, if you simply write a letter to the Department of Corrections and Rehabilitation, we'll act upon your request in your letter. We prefer the earlier the better. Obviously, once we have the jurisdiction of the offender and they're assigned a CDC number, it's a good time to fill out that form. We offer U.S. mail certification certified, and we can also email notifications to victims, as well as there is a lot of information posted on our website about offenders, such as what prison they're in, when their hearing is, and a proposed release date of the month and the year. When a victim is registered with our office and the offender is sentenced to a life term or a term that will allow he or she to have a hearing, the victim is notified 90 days in advance of that hearing, and they're instructed at that time to contact our office and make arrangements if they want to attend, if they want to send somebody in their spot, do they want to send a letter. We also make contact with the victims 180 days prior to the hearing and ask them if they'd like to attend. Many of them are virtual, and we clear that victim to participate in that hearing. We prepare them for the hearing and let them know what the hearing process will be like in advance. It is about a 4 to 5 hour hearing. The first portion of the hearing is very judicial in nature. They're going over the laws, they're going over the rights of the offender. They talk a lot about the crime and what happened and the conviction. Victims get to take all that in and listen before they make their statements, and they make their statements final before the decision is rendered. That hearing could be denied parole. Offenders can be denied 3, 5, 7, 10, or 15 years at a time. Under Marcy's law in the state of California, we do have direct victims, obviously, that participate in hearings. Many of their family members are also allowed to participate in hearings. Also, there's victims that are described as being harmed, of course, and they may not fall into the normal category of being a victim. Victims have up until 15 days to advise they want to attend the hearing. If it's a family member of a victim, maybe a next of kin, they do have to give a 30-day notification in advance if they want to attend the hearing. We do collect restitution for victims on behalf of the victims. So we collect per court order, per a judge's order. Often it's attached with the criminal conviction that comes in. We will collect on that when the offender comes into state prison. Also, if there's a direct order established for a victim, the order needs to say the victim's name and a set dollar amount. We cannot collect on TBD orders to be determined. We encourage the victim to go back with the district attorney's office, establish a set amount that they were out of pocket, that they lost, and we can go ahead and start collecting on that. We can't collect on unknown victims. If there's a court order that says unknown, we're not able to collect. So when the offender does come to state prison, while they're in state prison in our custody, we do collect. If they have any unpaid balance of a direct order to a victim, in 90 days approximately, that balance that the offender owes is transferred over to the Franchise Tax Board in the state of California, and the Franchise Tax Board will take over collections, and they'll work with the offender, now the parolee, to establish a payment plan and assist in getting that victim still their compensated money for their losses. Victims also want to share their thoughts and have a statement on the record of all types of cases. We have information on our website about victims' impact statements and how to write them. If you're going to submit a victim impact statement for a parole board hearing, it needs to be timely. The board has to review it in advance. There is a process if a victim is fearful or maybe has information that they don't want to share, that they can write a victim impact statement and deem it confidential. It's a process that the parole board will review along with Division of Adult Institutions, DAI. Once that statement is deemed confidential, it is scanned and placed in a file that only the board members would be able to see it. Our agency and our staff will provide accompaniment to victims during the parole board hearing process if they request that of us. We're able to attend the hearing with them, as well as we are able to easily get them transcripts of the hearing so they have it for their records. Under California state law, there are some crimes that a direct victim of a crime can request a 35-mile radius, which would mean the offender would not be able to be around them the radius of 35 miles. Also, they can request a no contact, of course, which means that they're requesting no contact with the offender once released or in prison. And once the offender is released on parole, that no contact will still be in place. If you're a victim of crime, I encourage you to reach out to our department. Even if you don't know what your rights are, please contact us. We have a toll-free number, and we also have a website at cdcr.ca.gov. It has loads of information about your rights as victims, restitution, restorative justice. You can also find the offender, the location of the offender, possible release date of the offender, and when the hearing may be. Also reach out to us via live chat. Our website has live interactive agents that you can instant message anytime and get a response.